I want to thank Chairman Boss for his leadership on this issue. Getting a version of the legislation into the House-passed Milcon VA bill and then into the minibus in March was a huge win for our veterans. This legislation is needed as it would fix and make a permanent fix. We have heard from our Democrat colleagues about how this legislation will increase veteran suicide. This is blatantly false. No studies or data show that veterans whom the VA deems incompetent are at a higher risk of suicide by firearm. The RAND Corporation and the Congressional Research Service confirmed this fact. We do know, however, that sending a veteran's name to the National Instant Criminal Background Check System without due process does disincentivize veterans from receiving the health care that they have earned. Cole Lowell from the Mission Roll Call confirmed this fact in our legislative hearing on July 18th of 2023 by acknowledging some veterans feel that their Second Amendment rights would be infringed upon if they sought health care, particularly mental health care at the VA. Treating a veteran who needs help managing their money fiduciary as a criminal is wrong. Veterans served our country honorably, and I am outraged. If not for Republican efforts, the VA would still be treating them like second-class citizens simply because they choose to have someone handle their financial affairs. I wonder how many others would fall into this category for using the services of a professional bookkeeper. Additionally, the Supreme Court found in Heller that the Second Amendment guarantees, I quote, guarantees the individual right to possess and carry firearms in the case of confrontation. And in McDonald, the court established the Second Amendment to be a fundamental right applied equally to the federal government and the states. The way the VA previously interpreted the statute was blatantly unconstitutional and an affront to the Supreme Court and the separation of powers. While I support this bill, there's some more that Congress must do to support veterans whose names have already been sent to NICS. I welcome the opportunity to discuss Congressman Crane's amendments that will strengthen this underlying bill. Thank you very much, and I yield back. I want to thank Congressman Crane for this amendment that would strengthen the underlying bill. While the legislation as written would protect veterans from having their names sent to NICS if they do decide to use a fiduciary to help manage their money, the legislation does nothing to protect the approximately 260,000 veterans who have already had their information sent to NICS. 260,000 veterans have already had their information sent to NICS. As referenced by Mr. Van Orden, in fact, 98% of the adjudicated mental health records in the background check system that were submitted by the federal government are veterans disarmed by the Department of Veterans Affairs. The 260,000 veterans deserve justice too, and Congressman Crane's amendment achieves this goal. Congressman Crane's amendment would require the Secretary of the VA to notify the Attorney General and each affected veteran who has had their name sent to NICS that they no longer are considered mentally defective. That's what they're considered, mentally defective, because they've decided to utilize the services of a fiduciary. This would restore the Second Amendment rights of approximately 260,000 veterans. I thank you so much, Mr. Chair. I urge my colleagues to vote yes on this, and I yield back the balance of my time. Mr. Chair, red flag laws are another way for the anti-gun extremists to strip Second Amendment rights away from law-abiding citizens, completely bypassing Americans' right to due process. Numerous states have already passed red flag laws that empower the government to indefinitely confiscate firearms from lawful gun owners. Data suggests that gun confiscation orders fail to reduce crime, mass murders, or suicide, and only punish law-abiding gun owners. This amendment by my good friend Congressman Crane simply prevents the Department of Veterans Affairs from cooperating with rogue left-wing states attempting to disarm American veterans. The VA was created to serve veterans and to provide them with quality health care and the benefits that they deserve and that they have earned. The VA's resources should not be funneled towards gun-grabbing efforts weaponized against our servicemen and women. Our country's veterans have been deployed all over the world to defend our freedom, and it is unacceptable for their rights to be trampled upon once they return home. I urge support for Representative Crane's amendment, and I yield back the balance of my time. Thank you very much, Mr. Chair, for holding this markup, and to Congressman Sherfless McCormick for your comments momentarily. I want to speak briefly about my bill, H.R. 6874, the Watching Over Electronic Benefits Act. As the chairman of the Technology Modernization Subcommittee, Ranking Member Sherfless McCormick and I have worked in a bipartisan fashion to ensure vigorous oversight of the VA's enterprise technology modernization programs and projects. In the past couple of years, there have been several problems that the VA.gov have impacted more than 120,000 veterans, and the VA has been slow to disclose them to Congress. Some of the errors are still not resolved and have negatively impacted veterans and their families. My bill, H.R. 6874, the Watching Over Electronic Benefits Act, would address these problems by requiring the VA to implement a process to actively monitor the VA.gov website for any adverse events that would impact the facilitation, maintenance, or receipt of VA benefits. The legislation would ensure that the errors are identified and improve Congress's ability to conduct proper oversight. Additionally, my legislation would require a testing strategy by the VA to reduce the number of adverse events that happen by improving testing for each modification or software update to anything that might impact the facilitation, maintenance, or receipt of benefits. This would get to the crux of the issue by preventing problems before they occur and harm the veterans. The United States Congress just spent billions of dollars on foreign conflicts overseas, yet we don't have a fully functional VA.gov website. As Congress, we must do better. I urge support for my bill, and I yield back.
Thank you, Congressman Rosendale. Does any other member wish to comment on the amendment?
Thank you very much, Mr. Chair. Mr. Chair, I want to speak in opposition to the VA Correct Compensation Act. Under current law, the Secretary of Veterans Affairs has broad authority to regulate the hours and conditions of employment for physicians, dentists, podiatrists, optometrists, chiropractors, registered nurses, physician's assistants, and dental assistants employed by the Veterans Health Administration. Those employees are prohibited from collectively bargaining over matters about professional conduct or competence, peer review, and compensation. Last Congress, I and nearly all my Republican colleagues voted against legislation that would have removed all this authority from the Secretary of the VA. If that legislation became law, it would be more difficult to ensure veterans are receiving the health care, benefits, and services that they've earned. It would have prioritized union interests over our veterans. I know that my Democratic colleagues will not be satisfied with just this legislation and will try to pass a more expansive bill next time they have the majority. This is simply the camel's nose under the tent. This legislation in question today would allow VA medical professionals to collectively bargain and grieve compensation issues where the VA doesn't follow the law, rule, regulation, or binding agreement. I agree with my colleagues that the VA employees who work overtime should receive proper compensation. However, I've tried to get hard evidence of employees not receiving overtime and this bill being necessary, and no one has been able to provide me any relevant data. We heard about two written examples, one from 2000 and another one from 2008. There's been lots of anecdotal examples, but zero hard evidence except for those two examples from 2000 and 2008. It is a mistake to pass a bill that attempts to solve a problem that does not exist. I urge my colleagues to vote no, and I yield back the balance of my time. Mr. Chair, I'm going to talk about the entire bill. I want to speak in opposition to the Trained VA Employees Act. The committee has done important, partially bipartisan work investigating the Office of Resolution Management, Diversity, and Inclusion. The investigation has made it clear that many VA employees in management positions lack the necessary skills, temperament, and judgment to be in leadership. Congressman Pappas's legislation would help develop mandatory training programs for current and future supervisors. I want to be clear, I am not against ensuring employees are properly trained. I think it was Henry Ford that said there's only one thing worse than a bad employee that stays with you, and that's a good one that goes away, or vice versa. I do not believe, however, that training alone can solve our problems. It needs to be easier to hold bad employees accountable. And all my Democrat colleagues voted against Chairman Buss to restore the VA Accountability Act. Everybody on the other side. I also have concerns about the nearly $30 million the legislation costs and extending the higher home loan fees as a pay-for, as my good friend Representative Self just referenced. The median home price in Montana is $609,900. It can take years to even save up 20% down payment for most of my constituents to pay for their first home. The VA Home Loan Program helps veterans, service members, and eligible spouses become homeowners. There is no down payment required. Veterans receive competitive interest rates, and there is no need for private mortgage insurance. I cannot support legislation that would make it more expensive for veterans in Montana to buy a home so we can have a training program for employees, yet we refuse to hold bad employees accountable. Unfortunately, my friend Congressman Self withdrew his amendment to attach employee accountability language to this bill. If his amendment had been adopted, I would have voted for the bill. But that being gone, I just cannot support it. Without this essential amendment, I urge my colleagues to vote no on the underlying bill, and I yield back the balance of my time.